Fox 54 verifies all your burning questions. Government shutdown. How long can lawmakers hold out from keeping it open? And you might have seen some mushrooms pop up in your yard. Are they toxic? Here's a rundown of all we've verified this week. President Trump's crackdown on illegal immigration has heightened concern among the nation's undocumented workers. With facility raids and National Guard troop deployments, the effects are being felt from coast to coast. But is the concern limited just to the workforce, or do those doing the hiring have reason to worry as well? Can Alabama employers be punished for hiring undocumented immigrants? We verify. Most of us know about the repercussions undocumented immigrants face if they are caught: detainment, likely deportation, and other consequences. But do those who facilitate their livelihoods face their own reckoning? Let's verify. Our sources are the Code of Alabama, federallawyer.com, federal court records, and the U.S. Citizenship and Immigration Services. Here's what the Department of Homeland Security has to say about these things. The federal government considers a business to have knowingly hired an unauthorized person if it enters into, renegotiates, or extends a contract or subcontract to obtain the labor of a person it knows is not authorized to work in the United States. And in such cases, DHS may impose penalties if an investigation confirms such findings. The department will issue a notice of intent to fine when it intends to impose penalties. If you receive this notice, you can request a hearing before an administrative law judge, but the clock will be ticking. If DHS does not receive a hearing request within 30 days, they will impose the penalty and issue a final order, which cannot be appealed. According to federallawyer.com, that fine can range from $250 to $10,000 per illegal employee hired, depending on how many times the employer has been found to have hired such employees in the past. If you or your business are convicted of engaging in a pattern of knowingly hiring unauthorized people, you could face both fines and up to 6 months of imprisonment. The state of Alabama also has its own laws on this matter. According to state code, no business entity, employer, or public employer shall knowingly employ, hire for employment, or continue to employ an unauthorized alien to perform work within the state of Alabama. Upon the first violation of this law, the court can order the employer to terminate the employment of every unauthorized person. They can subject the business to a 3-year probationary period during which they must file quarterly reports. They can order the business to file a signed, sworn affidavit with the local DA stating that all unauthorized employees have been terminated and that they will never knowingly employ an unauthorized person again. And they can suspend the business licenses and permits of the business for up to 10 days. So we can verify that yes, Alabama employers can be penalized for knowingly employing undocumented immigrants. However, in the past decade, few, if any, federal cases have actually been filed against employers in Alabama for hiring undocumented immigrants. If you have something you want us to verify, text us at 256-382-2692. Yesterday marked 2 years since Steve Perkins died by the hands of a now former Decatur police officer in Perkins' driveway. That trial, scheduled in November. This past Sunday, a woman shot and killed a would-be burglar who broke into her home. And so the stand your ground law is on many of our minds. It's been used in successful defenses in Alabama many times, but when does it actually apply? Can you use deadly force on anyone who comes into your property without your permission? Let's verify. Police say a man was shot and killed while trying to burglarize a home in Decatur Sunday. Was the homeowner justified in wielding deadly force against a would-be thief? When does stand your ground law apply? We verify. Our sources are the Alabama Code and attorney Joe Lampley with Joe Lampley Law Offices in Huntsville. According to Alabama Code Section 13A 323, a person is justified in using force if they reasonably believe it is necessary to prevent imminent unlawful force against them. But this standard hinges on reasonable belief. So what is that? We asked attorney Lampley.
That's not necessarily a clear black and white standard. You simply look at all the facts, the totality of the circumstances, and try to derive from that what would any other typical person in this particular factual scenario, what would they have done? And that's why the statute allows for a reasonable person standard.
The law also distinguishes between non-deadly and deadly force. Non-deadly force is allowed when necessary to defend yourself or another from unlawful force. Deadly force is justified only when necessary to prevent death, serious physical injury, or the commission of a violent felony. But what about the incident in Decatur? Does a break-in justify the use of deadly force?
if someone is committing an offense and there is they are not engaging in any unlawful or attempt unlawful physical force against you, you're not free just to take your gun and shoot someone or to stab someone. Now that's a little tricky area because we've had cases where someone is trying to break in your home, and on the other side of the door, you don't know whether they're armed or not armed. And so you engage in some behavior that you reasonably believe that this person on the other side of the door is getting ready to kick your door in, or they're trying to kick your door in, but you don't know whether or not they are armed or not armed. In those type of situations, it's not black and white.
The law goes on to state that individuals have no duty to retreat before using force in self-defense. This is why it's called the Stand Your Ground law. You have the right to stand your ground when facing an imminent threat to yourself or others. But this law is still open to interpretation. Courts must consider factors such as provocation, the nature of the threat, and whether the response was proportionate. So we can verify that the Stand Your Ground law applies when you are facing imminent danger on your own property. However, what justifies deadly force under this law is a decision up to the court's interpretation of the circumstances of each case. We do want to note no charges are expected in Sunday's shooting in Decatur. If you have something you want us to verify, text us at 256-382-2692. Last night, the U.S. entered a government shutdown, the 21st in our nation's history. Though it's a big deal, it's hardly unprecedented. But something many of us haven't seen before is the Senate leaving the floor hours before the deadline without an approved funding bill, which raises the question, could Congress simply stay away indefinitely, leaving federal workers across the country unpaid and the economy on a tightrope? We verify. This happens nearly every year. Republican and Democrats haggle over the funding bill for weeks, leaving Americans on edge as we wait for lawmakers to reach an agreement before government shutdown begins. And this is far from the first time it's come to that. The last shutdown in 2018 was the longest in U.S. history at 35 days. But what incentive does Congress have to spend long hours on the floor working to come to an agreement? Does anything prevent an impasse that could drag on for weeks or months or even indefinitely? Let's verify. Our sources are the United States Constitution, Congress.gov, and Senate.gov. One possible reason Congress would want to end a shutdown is so they can be paid. But according to the U.S. Constitution, Congress is paid automatically by the Treasury, meaning members receive their checks whether other parts of the government are funded or not. So what's stopping members of Congress from simply staying home? This is also laid out in the Constitution. It says that each body can, quote, compel the attendance of absent members in such manner and under such penalties as each house may provide, end quote. In 1798, the Senate adopted a new rule specifying the penalties for enforcing senators' attendance. That rule states that the Sergeant-at-Arms has the authority to bring absent members back to the chamber. The current Senate Sergeant-at-Arms is Jennifer Hemingway, but she can only bring absent members back to the chamber when it is in session. She does not have the power to make them convene or stay in chambers indefinitely. So could President Trump tell Congress that they cannot leave the floor until they come to an agreement? The president does have the authority to convene Congress on extraordinary occasions, typically involving national emergencies, declarations of war, or the need for immediate legislative action. However, the president does not have the power to force Congress to stay in session until they agree on something. The House and Senate decide when they're in session, when they take breaks, and how long debates last. So we can verify that yes, a government shutdown can continue indefinitely until Congress passes legislation and the president signs it. There's no timer or constitutional deadline that would bring it to an end. What usually ends shutdowns is political pressure, economic impacts, and/or public opinion. If you have something you want us to verify, text us at 256-382-2692. If you have a yard, you're probably seeing mushrooms coming up left and right. It happens every year right about this time. Some mushrooms are harmless, others deadly. So what about the ones we find around our homes? Are the mushrooms growing in your yard toxic to your pets or even your children? We verify. Green-gilled chlorophyllum molybdites, genus Calvaceae, Omphalotus illudens. These are just a few of the mushrooms you may see pop up in your yard this time of year, despite it being the driest season. Some of us pay them no mind, but those with pets or small children may worry whether they're toxic to their most vulnerable loved ones. So, which ones, if any, are dangerous? Let's verify. Our sources are the founder and president of the Alabama Mushroom Society and the North American Mycological Association. According to Anthony Goodman, the founder of AMS, all mushrooms can be safely handled without toxic effect. He says most wild mushrooms require cooking to consume. But what kind of mushrooms are growing in your yard? The most common types are the green-gilled chlorophyllum molybdites, also known as the vomiter, which might give you a clue about its edibility. Spoiler alert, don't do it. The vomiter is notorious for causing GI upset when eaten raw by people or pets. The genus Calvaceae are those giant puffballs, and they're edible when completely white inside. Once they develop any yellow, brown, or purple coloration inside, they should not be eaten as they could cause stomach issues. Some species in the fall Amanita category are toxic. But the peachfly agaric, which is most common here in North Alabama, is only mildly so. The Omphallatus illudens, or the pumpkin orange mushrooms that glow slightly green in the dark, they are toxic and can lead to severe nausea and vomiting. So we can confirm that yes, some of the mushrooms growing in your yard are mildly toxic, but not deadly. That's it for this week's Fox 54 Verify. If you have something you want us to verify, text us at 256-382-2692.